Greeting to the viewers. This is Shashank Mishra as a host with the eminent senior advocate of Supreme Court of India, Subodh Markandeji. Today we will be discussing on important topic that is reservation for EWS upheld by the Supreme Court. So there are banners, headlines in the newspaper about the judgment of Supreme Court of India upholding the constitutional validity of the reservation of the economical weaker section. Please give some details about the judgment.
In this marathon effort of the bar and bench of the Supreme Court, over 40 cases, that is writ petitions and transferred cases, that is transferred from the High Courts under Article 139, which provides for transfer of cases to Supreme Court where similar cases are pending before the Supreme Court of India. So these 40 cases were disposed of by 5 honorable judges of the Constitution Bench. In all, 4 judgments have been rendered. 3 separate judgments by each of the judges who upheld the constitutional validity, that is the majority view, and 1 judgment by Justice S. Ravindra Bhatt for himself and on behalf of the Chief Justice of India, Uday Umesh Lalit, who struck down this bench, majority, that is minority bench, struck down the Constitution 103rd Amendment Act. So in view of the majority judgment of Justices Dinesh Maheshwari, Bela M. Trivedi and J.B. Pardiwala, the challenge to the Constitution 103rd Amendment Act has failed. So this is the outcome of the marathon effort. The leading majority judgment was delivered by Justice Dinesh Maheshwari. It runs into 155 pages, having 106 paragraphs. The concurrent judgment by Justice Mrs. Bela M. Trivedi, running into 23 pages and 29 paras, and another concurrent judgment by Justice J.B. Pardiwala, running into 117 pages and 192 paras. These judgments were delivered upholding the constitutional validity of the 103rd Amendment to our Constitution. So the single dissenting judgment striking down this 103rd Amendment by Justice S. Ravindra Bhatt runs into 101 pages and 197 paras. So let us briefly note what was the relevant reservation scenario before the enactment of 103rd Amendment to the Constitution. Reservation had been provided by the Constitution and the laws in 2 fields. One is one set of reservation is admission to public educational institutions, largely government educational institutions. There is provision of revision. And the second is admission to the public services, that is government services and maybe public sector undertakings and corporations, etc., because they follow the same pattern. So a reservation was given to the citizens who belong to the scheduled caste, scheduled tribes, and other backward classes. So the total extent of reservation had a ceiling limit of 50%. Now, broadly, the distribution of reservation was 15% to the scheduled caste, 7.5% to the scheduled tribes, and the rest for the other backward classes in both the fields of admissions to public education, educational institutions, as well as the public services. Now, let us briefly see what was the 103rd Amendment to the Constitution and its effect. So, the 103rd Amendment Act is a short act. Section 1 is a formal one, that is to say, short title, and commencement. Section 2 provides for insertion of clause 6 in Article 15 of the Constitution. Section 3 provides the insertion of clause 6 in Article 16. Now, what is the effect? By insertion of clause 6 in Article 15, the state, that is to say, as understood in Article 12, is enabled. It's an enabling provision. So the state now can make special provisions for the advancement of economically weaker section of the society. I will call it EWS. Insofar as the special provisions relate to their admission to the educational institutions, whether aided or unaided. This is important. Unaided are also now in the net,
Yes, sir.
aided or unaided by the state. Other than, of course, the minority educational institutions. Uh, uh, and that is to say, what are the minority in educational institutions? Those mentioned in Article 30 of the Constitution, which in the case of reservation would be in addition to the existing reservations. That is to say, now they can exceed the 50% and subject to maximum 10%. So these will, the EWS will have 10% reservation
Yes, sir.
of the total number of seats in each category. That is to say, in educational institutions as well as the services. There is an explanation to this clause which defines what is economically weaker sections of the society for the purpose of both Articles 15 as well as 16. So these will be, this explanation says that EWS for the purposes of both Article 15 and 16 would be uh, 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 those persons who are other than HCs, STs, and OBCs. So these will be in all 10% in both categories. Uh, so now, what is the basis for arriving at is that as notified by the state from time to time on the basis of family income and other indicators of the of economic disadvantage. So I think this is little problematic in my view. In future, there is too much of ambiguity, and then there is too much has been left to the state to determine. So at present, they have said that those who have income or family income of uh, 8,000 rupees per month. So this is a little problematic. In future, litigation will be there on this basis. So, in my view, this may cause further litigation. So, this is the total take of the uh, article uh, 15 and 16 as amended by the 103rd articles 15 and 16 as amended by 103rd Constitution Amendment Act. So, these by inserting clause 6 in Article 16, the state has been enabled to make provision for reservation in the uh, appointments of uh, posts in favor of economically weaker sections of the society, other than the classes mentioned in clause 4 of both the articles. In addition to the existing reservations, subject to maximum ceiling of 10% of the posts or seats, as the case may be. So, this is the total effect.
So, what in short are the benefits of the majority judgment, sir?
Now, you, we all know that, the the present reservations are based on caste, tribe, and class. No? Scheduled caste, scheduled tribe, and other backward classes. Now, conceptually, the reservation which has been now enacted by 103rd Amendment is individual based. This is what I understand. So
Yes,
this
sir.
is a good start because it's the individual who should get the, if he is meritorious, he gets. So this is the best part of Article uh, of 103rd Amendment to
And
the Constitution. The majority judgments of Justices Maheshwari, Trivedi, and Pardiwala uphold the reservations in favor of the economically weaker sections, which will be to the extent of 10%, in addition to what's already there, 50%. And this is this 50% has been there since a very long time. First, it was mostly in the educational admission to educational institutions, then it was extended to services. So total ceiling limit of 50% has always been there since long. Now, the new reservation in the educational sector and the public services should really be, it gives a great opportunity as well as challenge to the aspirants belonging to the economically weaker sections. To my mind, 10% is adequate to meet the uh, needs of all the economically weaker sections of the society. So it will, I hope, it's quite huge. So it will, I hope, satisfy the aspirations of a very sizable number of young people.
so will the candidates getting admission into the privately run institution of higher education get any concessions in the payment of fee?
I think this will be problematic because because all those private educational, whether we like it or not, they run on profit. So I
Yes,
don't
sir.
think any uh, commercial, semi-commercial, or whatever, they would like to cut into their profits. So this is a very weak element of the whole thing. Uh, so I think what will happen is that fiscal loss is not acceptable to them. Will not be. It's not easy that they accept the fiscal. So what is the effect of all this? Those are very high fee educational institutions. We have seen, I don't know what are the fiscal, but like so many people from, let us say, Jindal World Law School, they come as, uh, uh, they come to my chamber as trainees, And so one of the questions, which is usually they are also quite forthcoming in telling what their parents have to spend. So it's quite
Yes, sir.
quite quite high. So that will be one of the reasons that this is making it a mirage. So I don't know how that will work out in future, unless a very large number of scholarships are provided. It is incorrect to say that that will have any impact on the aspirations of young people. So private educational institutions may not be a good sop. Uh, so as I said, you will have to provide on very significant scale uh, scholarships there in order to make it meaningful.
Sir,
This is my view.
has the
Yeah,
controversy finally ended?
yeah. Controversy, as I said, has You can't you can't predict whether the controversy has ended. As I said, uh, explanation to Article 15(6) will definitely, the definition of economically weaker section will definitely give rise to litigation. If not now, now some criteria has been made and that has been upheld by the Supreme Court. Now, if the criteria is changed, then definitely it is going to, uh, cause litigation in future.
So that's all for the day. We have known all about the EWS. Thank you, sir, for giving your time and telling all about it.
Thank you.